Hello and welcome to a new podcast series that we will be doing on exclusively employment law. So I'm Abel, Head of Employment here at Oakwood Solicitors. I've been a qualified employment solicitor since 2009 and deal exclusively with employment law.
And my name's Daryl Smith. I work as an employment paralegal at the moment. I've been in the law industry since 2018, since graduating.
So this will be an ongoing podcast series. We're going to do a number of different topics which will all vary in length. Hopefully we'll try and keep them nice and short and sweet for you and quite informative. But we also plan some more long form conversation on perhaps some of the more complex topics to come. So this week's episode will be focusing on the very basics of unfair dismissal.
Yeah, so a good start there, Ian. What is unfair dismissal? I think is a perfect way to start this particular podcast. So generally speaking, there are some exceptions which we'll cover in a separate podcast in the future, but an employee who has a qualifying period of service has the right not to be unfairly dismissed. Dismissal in this context means one of three things, usually either termination by the employer, the expiry of a fixed term contract, or constructive dismissal.
Thanks, Daryl. So you mentioned the qualifying period of service. That is currently 2 years. That changed in 2012, and sadly, I'm old enough and have practiced long enough to remember the case before 2012, where it was only 1 year. So we're effectively saying that you have to be employed for at least 2 years in order to have an ordinary unfair dismissal claim. We say 2 years. What we actually mean is 51 weeks if the company was then to serve you with notice to work your minimum period of notice, which is 1 week, which takes you to the 52 weeks. Yeah. So unless you were getting paid in lieu of that notice, you have to have 51 weeks service to have an unfair dismissal claim. So the dismissal of somebody with the qualifying period of service will be unfair unless the employer can show that the reason or the principal reason, if there are more than one, was one of the 5 fair reasons for dismissal, and that the tribunal finds in all of the circumstances, which does include the employer's size and resources, that the employer acted reasonably in treating the reason for dismissal as sufficient to be dismissed. A practical point here to note is that smaller businesses will have a potentially lower threshold than a very large company in terms of their size and resources.
Yeah, and so you mentioned then, and very importantly, with regards to unfair dismissal, is the 5 fair reasons for dismissal. So we'll go through those. The first one being capability. That's your capability not just to discharge the role professionally speaking, as such as your performance, but also your capability from a health perspective as well. Conduct, which is the most common reason for dismissal. A lot of people have heard that, things like gross misconduct in general. It relates to the conduct of the employee. Common examples are unauthorised absence from work, theft, failure to follow a reasonable management instruction, etc. It's very, very common. Statutory restrictions, sometimes called illegality. It means it's illegal to continue to employ that individual. Common example is an expiration of a work visa. Redundancy, which everyone knows the buzzword of redundancy. Legally speaking, for this to be the reason, must adhere to one of the 3 situations. The business ceases or intends to cease the work that the employee actually does. The business is planning on closing a place where the employee is employed, or there is a reduced requirement for employees doing that role. Finally, the last reason is an SOSR, also known as some other substantial reason, which is essentially a catch-all for all of the reasons which fall out of the other 4 reasons as described previously. Topical example at the moment might be that the individual who was harassing Professor Chris Whitty filmed it, silly put it all over the internet, thinking that it was a very clever idea. Wasn't conduct in the workplace, but was conduct out of it, and in the case of that individual, if he was a qualifying employee, the reason might be bringing the business to disrepute. His employer has been named in the press, got a lot of bad rep as a response as that. There's also the individual at the moment who is currently being investigated by Savills. He's the individual who has allegedly tweeted racial abuse towards individuals of the England football team.
Thanks, Daryl. One, again, probably showing my age here, but one thing that is not any longer a fair reason for dismissal is retirement. Right. I can remember qualifying. There were 6 reasons to fairly dismiss somebody, but over time that has been having a default retirement age, as we used to of 65, has been held to be age discriminatory, so that reason has been removed. So retirement is no longer a valid reason to dismiss somebody, and it is potentially age discrimination. So we hope that you've enjoyed our first podcast. This will be the first of many, hopefully, and we would be delighted to receive any feedback, good or bad, to try and make this podcast as informative for you guys as possible. So please, I hope you've enjoyed this, and please tune into our next one.
Yeah, and if you've got any questions at all or any further information that you want to seek, please feel free to get in touch with either myself, Daryl Smith, or my colleague Ian Abel on LinkedIn, or get in contact us with the Oakwood website.
Oakwood Solicitors, the experts in employment law claims. For any inquiries, please call 0113 200 9787 or email us at inquiries@oakwoodsolicitors.co.uk. Anything contained in this podcast is for information purposes only and not intended to be specific legal advice.